Parties in a lawsuit sometimes need to obtain documents or information that are in the hands of someone who's not part of the suit. The way that a party in litigation gets a hold of those records is by serving what's called a third-party subpoena or a non-party subpoena, which is exactly what it sounds like. It's a subpoena being served on someone that's not part of the litigation. Common examples for the use of a non-party subpoena are to get medical records or financial records, but a third-party subpoena can be served really for many reasons. You might own a company that works in a project where a dispute comes up between other companies working on that same project, and they think you have relevant information. Maybe your company employed an individual, or maybe as an individual you worked for a company that ended up in a lawsuit down the road, and again, those parties think that you have information that's relevant to their dispute. You'll also see fancy names attached to a subpoena. For example, a subpoena ducis tecum or a subpoena ad testificandum. That just means that sometimes you have to give up documents, sometimes you have to sit and give testimony under oath. Sometimes you have to do both. Here's the most important thing you need to know. If the lawyer serving that non-party subpoena has done their job correctly, you are legally obligated to comply with the requests in the subpoena unless you timely raise an objection or seek protection from the court so that you're excused from compliance. You've got to follow the rules and meet your deadlines, or else you're going to waive your chance to object to that subpoena. Some common reasons to object to a non-party subpoena are that the requests are unduly burdensome. You're being asked to do too much to give up that information. The request may be vague or ambiguous. You don't understand what's being asked of you, and so therefore you can't comply with the subpoena. And this one's important. Sometimes you're asked to disclose trade secrets or confidential information, and you don't want to have to do that. All of those objections have to be raised timely. Lawyers sometimes see a third party that gets a subpoena and thinks, I shouldn't be involved in this dispute, and they ignore the subpoena. That's a bad idea. A third-party subpoena can be enforced in court, and the respondent can be held in contempt of court for failure to observe the subpoena. Finally, one other point to consider is that even if you're not a party to the suit yet, someone might be thinking about adding you. Maybe you've got insurance, or they see you as a deep pocket that can be brought to the table to help achieve a settlement. Talking to a lawyer is a good way to assess your rights and your potential exposure when complying with that non-party subpoena.